Without further ado, I think we're running a bit behind. I'd like to introduce our next speaker. You may have seen him on TV talking about this very topic, which is the update on the Copyright Amendment Bill. It's a very topical issue at the moment, and I think it's going to be a very interesting discussion. I'd like to welcome Stephen Hollis to speak to us. He's an IP attorney specializing in trademark, copyright, and entertainment law, and he has a passion for arts and creative industries and assisting clients to grow their businesses through the effective management of their IP rights and assets. Thank you. Welcome, Stephen.
Thank you, Maureen. Hello. Hi, everyone. Am I fully audible? Yes, I can hear myself. So after the inspirational talk this morning from the good news guy, I feel I've been cast as the bad news guy by bringing you a rather concerning update or two on South Africa's infamous and highly controversial Copyright Amendment Bill. Now, this process has been going on, this legislative process, for a long time. It had its origins around 2009, when a group of musicians went to the office of then President Zuma and said, "Mr. President, help us. It's been almost 7 years since needle time royalties were reintroduced into our law, and yet we haven't seen a single royalty distribution. What's going on?" And a commission inquiry was established to look at what's going on in the music industry, and that was one of the catalysts for the copyright reform project, because the commission inquiry resulted in a report called the Copyright Review Commission Report by retired Judge Ian Farlam, which made valuable recommendations for how legislative changes could help to improve the lot of our vulnerable creatives and musicians, but particularly in the music industry. The DTI then set out to update our law, but also took the opportunity, which is a laudable step on their part, to actually say, let's not just look at the music business, but let's actually do a broader inquiry and update our copyright law of 1978. People, that's before the internet. Yes, well before then. And to update our law to meet the challenges of the digital age, to see what can be done to improve the flow of information, especially in the educational space, to introduce new exceptions, balanced exceptions, and to also at the same time make sure that we are, let's call it, internet ready. So you might know the oldest and most prominent international treaty on copyright is the Berne Convention. Dates back to 1886. It's been updated several times since. But because of digital development, so our law, our 1978 law, is outdated, but it has stood the test of time because it was very closely modeled on the Berne Convention. So in 1996, WIPO adopted a couple new treaties. They call it the Internet Treaties. It's the WIPO Copyright Treaty and the WPPT Treaty, WIPO Performances and Phonograms Treaty. This is to extend those rights that the Berne Convention traditionally gave to authors and into the digital environment for authors, also performers and producers, right? So the next step for South Africa to take is, of course, to update our law so that we can accede to these treaties. And Parliament has already approved our accession to WCTT, WPPT, and also the Beijing Treaty for Performers. Now, this all sounds very good, right? But unfortunately, what happened is there was a change in focus at the DTI. The first bill that we saw was so laden with what we call copyright exceptions and limitations. These are the instances where it's not necessary to pay someone or to ask their permission before you make use of their works. It sets out to create copyright-free zones in our educational space. While that might sound good for educational institutions who think we're going to now pay less because we don't have to pay the authors and publishers for the use of their works, or for even reproducing entire works in instances, or for creating course packs and course materials without having to pay anyone. The problem is one of the fundamental reasons for copyright to exist is to incentivize the creation of new works of quality that we all like to enjoy. So if you disrupt copyright protections to a level where you don't have sufficient incentive as a creative or a writer, and think about it in the academic space, most of our writers, our authors in South Africa who write for a living, actually write for that space. That's not uncommon for a developing country. So if you cut them off from their earning capacity, who's going to write next year's syllabus? And that could create a huge conundrum moving forward for the very educational environment that you set out to protect in the first place. The problem with the bill, I should probably move on to a few slides since I see this ticker going down. Folks who know me knew that it's going to be tricky to contain me in 15 minutes. So folks, part of the problem with the bill is it's got a lot of good intentions, but unfortunately we know what famous road was also paved with good intentions. Good intentions doesn't in itself mean that you get the outcome that you want. And the biggest failure from the Department of Trade and Industry when it set out to draft this bill is that it did not do an economic impact assessment of any value. It did not consult broadly with creative industry stakeholders to see where are there problems that exist that we need to address through this legislative amendment. What they've done is actually do research that they never disclosed and that they announced before the first public hearings on the bill back in 2017 to the consternation of the creative industry at large, is to say that they've done research that found that copyright is public enemy number one. Copyright is what's holding back the growth of our creative industries. Copyright is an obstacle that should be overcome, and therefore they've introduced arguably the world's broadest regime of new copyright exceptions and limitations that exist anywhere in the world. So it weakens copyright protections in South Africa to an unacceptable and unprecedented and worldwide low. That's why local stakeholders are up in arms. That's why musicians marched on Parliament multiple times. That's why famous musicians even wrote a song called Vike Lamina, Help Me, sang that in Parliament in 2017 to the applause of the Portfolio Committee members, but they didn't listen to them. Think about it, 2009 you had musicians going to former President Zuma, then the copyright reform happened. Then 10 years later, the musicians are singing in Parliament saying, this is not the bill that we want. This is a bill that's going to give our rights to technology firms. This is a bill that ignores the value gap completely that governments around the world are looking at addressing in the European Union, etc. This is a bill that's taking away what we actually already felt was not enough protections, and it's throwing us to the wolves in the digital environment, all for the name of technological advancement, education, and all lofty sounding ideas. But the very grassroots people that were meant to be protected are not uplifted. So if you look at this slide, you've got many creative industries. This is actually a slide that I used and copied from presentations that I made to Parliament, the National Assembly, and more recently to the National Council of Provinces, to illustrate that if you don't do an economic impact assessment, you don't know how, you don't appreciate that there's not one creative industry that you're legislating for. There's so many. And even in one sector, let's look at, for instance, audiovisual. You've got feature films, you've got television production, you've got animation, you've also got advertising, commercials. So each one sits with different commercialization models, different business models, different needs, different rights management models. If you impose a rigid system across board, and this is what the bill does in many instances, and don't allow for contractual flexibility, you can kill an industry. You can kill investment in an industry. South Africa's film and television sector is one of the most promising in the world. The creative, let's call it, since the pandemic, we've seen a massive unprecedented rise in a consumer interest in new creative content. We all know it. We binge watch content like you, and then you move on to the next. We're like a bunch of digital grasshoppers in that way. We're relentless as users. We just want more content, and we don't just want any content. We want quality content, and we want quality local content. Local content is king. It's unbelievable how on platforms like Showmax, if you look at the figures, the local content that's placed next to Game of Thrones and some of the big international hits, Yellowstone, local content will always outperform the big international shows. But how do we get quality local content without investment? We cannot turn our backs on what are the requirements for international investors to bring the money, because local government is not going to invest in substantially in content production. And if you create an environment where you make it impossible for folks to actually consolidate all the rights in a project at the beginning of the project for the life of copyright, that's what the bill does. It has reversion rights of all sorts and profit sharing arrangements and obligations on what would be film studios to report their financial figures on every single act of commercialization and share profits with people. And if they don't do that, their directors can go to jail, or they could get fined up to 10% of their annual turnover. Let me tell you, when these decisions are being made as to where to bring big international content production projects, where the feature film, commercials, advertisements, and advertising is huge. Advertising contributed 3.5 billion to GDP last year. That can all be wiped clean, because it comes primarily from international parties, and internationals, when they look, they don't just say, oh, South Africa's great, love Cape Town, let's go get some sun, the rand is weak. They get lawyers, they get, unfortunately, guys like me, the bad news guy, to sit with them in a boardroom and to say, let's look at Australia, let's look at the UK, let's look at Croatia. Greece has become the new Hollywood in Europe, because what they did is they said, what do you need to be more attractive? Croatia as well. You see a lot of productions in Croatia. Star Wars was shot there as well. So, sorry, I'm actually running out of time. So I'm not going to give you a legal briefing here, but if you are interested to learn more about the serious legal concerns with the bills, you can actually have a look at Copyright Reform or Reframe. That's a book written about the problems with the bill. It's about 155 pages. We try to keep it short and concise. It was written by members of SIPL, the South African Institute of IP Law's Copyright Committee. We felt that it was necessary to actually just try to explain these issues better, not only to government, but also to lawyers and also to potential constitutional court judges that will likely have to look at this bill. It is going to end up there, folks. It is going to end up there. We won't have time to go through some of these issues, but I do want to leave you with a comment on fair use. I've got 1.5 minutes to do so. But before I do that, I haven't given you the update yet. The update is the National Council of Provinces adopted the bill on 26 September. So very recently, it's gone back to the National Assembly. If they adopt the bill, re-adopt the bill. Remember, President Ramaphosa rejected the bill in 2020. Thank you, Mr. President. And at that stage, on the basis of serious constitutional reservations, saying, I'm worried, a lot of these provisions look like they could amount to arbitrary deprivations of intellectual property rights. Number one. Number two, you followed the wrong process. You should have involved the provinces, which they agreed with, and that's why we had the provincial processes. And number three, you are not potentially not compliant with the very international treaties that you want to accede to, the WIPO Copyright Treaty, WPPT. This has serious and potentially constitutional implications. You can't just legislate in a way that conflicts with international law obligations. So a quick comment on fair use. The only reason I'm highlighting this, and you would have seen from the previous two slides, there's many other serious issues. I'm not against fair use. I'm not. I would love it. In America, they call it the right to hire an attorney. So the lawyers in the room have a lot of litigation to look forward to. The problem with the reason I'm highlighting fair use is it's the most controversial, and it's one of the provisions that will have the most dramatic impact on us in South Africa. Fair use isn't fair fair use is a statutory legal defense that I hold up if you sue me for using your work, consuming your work, distributing your work to others without permission. Then I hold up fair use as a statutory defense, and you have to knock down the shield before there's any inquiry into potential damages or anything like that. So in the South African context, and this you can look at if you find it interesting, and also those who are tuning in online, this is from the book, Copyright Reform or Reframe. Go and have a look at it if you're interested. On the left here, you'll see the construct in our bill. On the right, the US Copyright Act from where it was inspired. It's a much broader interpretation in our legislation that doesn't exist anywhere else in the world, not even in the United States. And that will allow you, as long as you don't substitute a work in the market and use it for a different purpose, you might be okay. So lastly, 20 seconds, bear with me. This photograph taken by Grant Williams, iconic photograph of the President Madiba was released from prison in 1993. And the photographer was at an art exhibition in Joburg, not to think in Maboneng, and he walked in there and he saw this on the wall. Hey, we can go back and show it again. It's his photograph, but repurposed in a way to invert the colors and to also introduce, like if you shine a light on it, it brings out certain colors to highlight certain different aspects to show a contrast, right? So it conveys maybe a different idea. This was done by an American artist who then raised a fair use legal defense, as it was reported in the media, not knowing that it's not yet law in South Africa. But if it is law in South Africa, or it becomes law in South Africa, what that would mean is that Graham Williams, and this was sold for $36,000 for the one. That's more than Graham Williams made collectively for the sale of his iconic photograph, mind you. And this guy didn't ask for his permission to do this. Now, under the new regime, what would happen is Graham Williams would need to sue him, take him to court, first knock down his fair use defense. And let me tell you something, I don't know if that qualifies as fair use or not. It does serve a different purpose. It doesn't necessarily substitute the work in the market. So that's why in the United States, you've got 10 years of litigation on a single case, and it tends to be the biggest companies with the deepest pockets. Which of our vulnerable creatives and artists and so forth can afford to take people to court? What will happen is they will acquiesce to infringement, and that's a very dangerous thing for cultural work production in any jurisdiction. In South Africa's specific context, and these folks who promote it and say, they have it in the United States, why can't we have it here? This just shares the name. It's fair use on steroids. We do not have statutory punitive damages like they do in the United States. If you misrely on fair use as a user who infringed, there's no risk for you. You're not going to get slapped with $10 million fines like they do in the United States. So what the DTI is doing is it's eviscerating copyright in South Africa, and it's turning it into a user-friendly paradise. It depends where you stand. Government love it. They're one of the biggest users of copyright works. Big tech love it as well. They want the flexibility to use works without permission. And so do others, and I've finally been reined in. I've been waiting for you to do that. I made it. I didn't think I would, but thank you, Marie.